under pressure, right? Which, you don't have to actually go out and speak in front of, a large audience to be under pressure, but you could just be talking to your manager, right? And so hopefully having these types of conversations where you're being challenged, right, can prepare you when you're going to be challenged in the real life, And the reason why I wanted to mention this is because, I don't want anybody to feel that, I'm doing this to, attack you or demean you or make you feel bad for, my own benefit. Because, as I said to you when we first talked and began this conversation, there's two things that I come into this teaching experience with in my mind. One, as I shared with you all, the university does not pay, adjunct professors, including myself, nearly what, should be paid to us for the services that we're providing. The amount of time that we take to actually, travel here 3 times a week at 8 o'clock in the morning, and the sacrifices that I've made even in my own personal life to get here are tremendous. And so I don't do it for the money, especially recognizing that what is being paid to us is like around $15 an hour, and when I charge my clients $450 an hour, no way, shape, or form, compensating us for what we're doing. But also, I do this because, as we talked earlier, what is it that we face here as a collective that binds both Latinos, working class Caucasians, and African Americans? What is it that we face here? What has been the reference point that we've talked about, throughout this class? What system? The caste system, right? The caste system. And in the context of this caste system, it has gone on for 400 years. This lawsuit that we are talking about today, that is based upon, again, violations of the 1964 Civil Rights Act. So again, you're talking about, again, the Civil Rights Act that, again, was created before any of us were born, including myself. So violations that have, again, been going on, right, since before we were born and continue to exist, and we're litigating these today. And so if we don't at least talk about this system, right, that essentially puts us in a position of inferiority from birth and creates a division amongst the people who are working class people in order to prevent us from being able to challenge the wealthy elite and demand a fair share of the wealth that we are creating, right? Demand better wages, better working conditions, etc., 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 then we have failed. If we allow our children to inherit the same caste system where they are placed at birth in a position of inferiority, then no matter how many cars we have, how many houses we have, how many coats, diamonds, or whatever, what good is that? Right? What good is it, even for the President of the United States, an African American, right, to have spent 8 years in office, and if he comes out of his house now, right, and tries to take a cab on the corner of Massachusetts Avenue and Calorama Road over by where he lives, and he doesn't have a Secret Service escort, and it's late at night, and there's again, how many cab drivers do you think are going to stop for him? Huh? How many? And if there's a Caucasian person, right, who is homeless, trying to get a hell cab right across from him, who do you think he's going to stop first for? Exactly. And this guy, again, was the president of the United States for 8 years. And so the point that I'm trying to make to you with respect to the way we have been conducting ourselves is that we are really at war. We're at war with the system. We're at war with the system. We have to be about the business of dismantling the system and creating a better system for everybody. And quite frankly, even the wealthy elite, we believe, they are being disserved because they are really, kind of managing and overseeing a system that's based upon unfairness and evil. And so they are, even though they're enjoying the benefits on one hand, from another hand, they're actually hurting themselves, right? So we, by creating a better system, will benefit everyone, right? But again, what I'm doing in terms of my teaching style for you, I hope you understand, is to prepare you, to engage with you, to challenge you, to push you, especially again in terms of preparation. All too often, people make comments, particularly about our people, to suggest that we're not prepared. Oh, they can't read. They can't write well, right? They can't articulate well, right? You come late. How many other comments are there? Thank you. These are the things that are said about us. And so, again, if you're not pushing yourself constantly, then you may fall into the trap of emulating what people are saying about you. Does that make sense to you all? So, again, I want to help you all. I want to help each one of you all to become change agents, disruptors. No one knows what's going to happen, when you all finish this semester. I had a student, I think we talked about it at the beginning of the class, really positive brother, got ready to celebrate his graduation. Went to a party at the University of Maryland. While waiting for Uber, God came up to him and stabbed him, right? Just like that. Right before graduation. Getting ready to graduate from this university and got killed. Because of what system? What system? The caste system. This young man who stabbed our student, right, thought that he was somehow superior to our student based upon what? Right. When in fact, in many ways, our student and he had some of the same values. They probably voted for Trump. This is true. This is true. Our student was, kind of conservative. Right? And, this guy, his parents are not, they're not amongst the wealthy elite. They're still working. One is working at the University of Maryland, right? Even. So again, this is my point. No one knows when you are going to be challenged in the manner that I'm preparing you to be challenged. But I hope and pray that as a result of you having this class, you will be ready to meet that challenge. And, I don't quite know, how I impacted, our student, right? Lieutenant Richard Collins. I don't know. But you know what? I have to say that the young man stood his ground. He stood his ground. And in death, people think it's the worst thing that happens or could happen to you. And, again, we're not here to teach, things that are not inside the book, if you will, in terms of the textbook. But I think, personally speaking, as one of Richard's professors, I feel that I did my job with respect to that young man. I did my job. And I think that even in the way he carried himself up until the time he died, demonstrates what we're talking about here now. Right? So, I pray that none of us have to face that particular challenge, but without any doubt, we are going to be challenged. We're going to be challenged. And I hope that, again, the experience that we've had during these weeks that we spent together have prepared you for those challenges. Does anybody have any questions about any of that? All right. So let's go to the. So Fridays I try to bring in something different. The past few weeks, a couple of things I want to share with you that I'm going to put into the blackboard. One is this article that was written by the Baltimore Sun, Ian Duncan and Talia Richmond, which I think gave some additional details. What was one of the ironic elements about this particular case that anybody recognized? Anybody recognize some irony in this particular case? Who were the plaintiffs? Who were the plaintiffs? Who were the plaintiffs? Mr. Muslim, who were the plaintiffs?
The HBCUs.
Huh?
The HBCUs.
HBCUs. Were the HBCUs the plaintiffs?
No.
Who created? Huh? The alumni. Why did you think the alumni were the plaintiffs versus the universities themselves?
Because it was bad luck on the university.
Hmm?
The universities weren't the ones suing.
No, I'm asking why was that?
They were the ones suffering.
Huh?
They were the ones who were suffering.
Alumni were the ones suffering to some extent. You're right, but why isn't it that the universities themselves sued? Because they were suffering too, right? The universities weren't able to teach the students.
Because they don't want the bad on them.
Huh?
They don't want to put themselves in a situation where they need something from the government.
That's a good point, because who pays for the salaries of the universities that are being sued? Who pays the salary? The government. Did you notice that? Did you understand that? So again, in essence, it is like the university suing its boss, right? So that would have been almost a conflict of interest, right? So again, it took a coalition of alumni. Did anybody notice the names of the plaintiffs? This is the actual most recent order, which gave the names of all the plaintiffs and the attorneys. Speaking of which, did anybody get a chance to contact any of the attorneys from the lawsuit to reach out to them? I didn't see any email for the extra credit assignment.
When is the deadline for that last time?
It was today. We'll extend that, but this is an article, and I can send out the link for this. This is the copy of the last order, and it gives the names of all the lawyers as listed right there for the plaintiffs. And one of the people here, Brenda Shum and John Greenbaum, as well as Ray McLean, are with the Lawyers Committee for Civil Rights Under Law. So you can check out that organization by sending them an email. This is their website right here. And hopefully their contacts will be on there. But I encourage somebody to take advantage of that. And we'll try to hopefully get them here for our next class. Another thing that I wanted to share with you guys before we get started is two things. One, I want to share with you this quick video that talks about the case.
Some people believe that the fight for civil rights is a distant memory, that the fight for justice and equality ended during the time of black and white TVs and historic victories in the courts. These battles were the beginning, not the end. Despite some progress over the years, we are still separate, and we are still not equal. I Am Solutions presents a literal case in point. It is one of the greatest stories never told. It's the story of the 2012 trial of the HBCU lawsuit against the state of Maryland and the historic imbalance of support for historically black colleges.
I think the imbalance, of course, started right from the beginning. As you know, our historically black colleges were founded because our governments did not provide higher education for people of African American descent. As a matter of fact, for a long time, it was prohibited in our country. But when our community realized that we had to do for ourselves, and missionary organizations, Quakers, and sometimes the Methodist Church and the Episcopal Church and others decided that it was morally wrong to not educate these young people and to bring them to a point that they realize their potential as well. But the real issue there was they were forging ahead to provide the opportunity with less resources than you would find at our other institutions. And so this continued right on up until the Brown decision, in which Brown declared that no longer would we have separate but equal in elementary and secondary education. But that also was applied to post-secondary education and became more clear during the Civil Rights Act of 1965.
Congress passes the most sweeping civil rights bill ever to be written into the law.
This Civil Rights Act is a challenge to all of us to go to work in our communities and our states, in our homes and in our hearts, to eliminate the last vestiges of injustice in our beloved country.
But there was never an attempt then to go in and remedy some of the disparities between the black colleges and the white colleges. And so this disparity has grown rather than narrowed, and so we still find ourselves in that position today. There still has not been comparability between our traditionally white institutions and our predominantly black institutions, and that the only way to do it is perhaps for federal action. It was only when there was federal action that slavery was abolished, that only when there was federal action did we have segregation eliminated. Only when there is federal intervention, i.e. the courts in this instance, will there be some resolution of the great disparities that are now between the black institutions and the white institutions.
Despite some progress, the state's obligations are far from being finished, and the lawsuit is a necessary means to address the unfinished business of civil rights and desegregation in higher education. Those bringing the lawsuit came to John Britton and the Lawyers Committee with binders of notebooks full of documents that stretched back over 25 years.
And these documents show that Morgan State University in particular, and the three other historically black colleges and universities, these documents show that the state of Maryland has inadequately and unequally treated the HBCUs. And so, as a result of studying, the Coalition for Excellence in Higher Education of Maryland decided to bring a civil rights lawsuit against the state of Maryland, claiming violations of law for the unequal treatment of the historically black colleges and universities.
Is there a racial divide in higher education in Maryland? The state's historically black colleges and universities say yes, claiming they're underfunded by more than $2 billion.
The lawsuit is a traditional civil rights lawsuit, somewhat similar to Brown versus Board of Education. It declared that separate and unequal education was unconstitutional. There was another lawsuit in the early 1990s called Fordyce versus the state of Mississippi. This lawsuit set the precedent for the way the former Missouri states had to treat their HBIs. And Fordyce says that you have to do more than just stop segregating white students going to white schools and black students going to black schools. You have to treat the HBCUs on an equal level, and to some extent, you have to give the HBCUs more to make up from the past abject era of discrimination and segregation and inequality against the HBCUs. And so this lawsuit is a pattern after the famed Fordyce case and the law of Fordyce. And the law of Fordyce shows that in the modern day, if an HBCU says that it is still being treated unequally, although 20 or 30 years have gone by since segregation ended, the HBCUs and their supporters have to show that current policies are traceable back to the de jure era. And this lawsuit set out on about 4 legs of a table to make this proof. Firstly, the lawsuit says that the HBIs in Maryland have what is called a dual mission. Their mission is not only to provide a comprehensive education like the traditional white institutions, such as the flagship University of Maryland, but they also have a mission to educate high school graduates that are not quite completely ready for college. The traditional white institutions don't have that dual mission. So the suit says that the mission has kept the HBCUs down. So next to missions came what is known as the duplication of educational services. This was almost the sine qua non, shall we say, of this Fordyce case. Under the duplication of educational services, the court said, in essence, that when segregation was created in higher education by these states, the state could not create a white institution of higher learning that taught, say, a master's in business administration, and right down the street or in the same geographic area have a historically black institution that also offered a master's in business administration. This, the United States Supreme Court said, is a duplication of educational services and violates the Equal Protection Clause because it perpetuates the racial segregation by creating these programs where whites will largely go to traditional white institutions to get a master's degree in business administration, and they will bypass the historically black college and university that had previously been offering an MBA degree. So that's the kind of trickery that they've been playing all these years, and they're still doing it today. So we go to the third prong now, and that is unequal facilities. Now, you don't need to be an expert, and you don't need any more than just drive around with your smartphone camera and compare the facility at the University of Maryland flagship, or at Towson University, or Salisbury University. But you just drive around any of those traditional white institutions and look at their citadel of buildings. Look at their grass and greenery and yards. Look at their athletic facilities, including their student and all of its facilities.
You know that.
And as the saying goes, even Stevie Wonder would see that Stevie Wonder, the great musician, is blind. And so we claimed in the suit that the facilities are unequal. And lastly, I would say the pillar is really the overall reputation and the overall stigma. HBCUs suffer from a stigma because they grew up in the stigma. In fact, they grew up in the sin of our nation known as segregation and slavery and unequal treatment. And so in order to come out of that stigma and image, even though desegregation stopped segregation, the state has to do much more to improve the image so that people don't think they're going to a, quote, black school in any negative connotation. But let me quickly add, despite their unequal treatment, they have survived against the odds. They have exceeded against their expectations because they turn out many highly qualified graduates who go on to very distinguished careers and achievements in life.
That's part of the story that's never been told. How great these people are, how committed they are. People who care and then share what they have to ensure that the students go where they need to go. Yet, the unfairness of it all is a major factor. We can't continue to ask our faculty to do more than those at our other institutions. It's the fairness of it all.
This right here was actually a movie that was created before the actual case was argued, or actually after the case was argued, or while the case was being argued, before the decision had been reached. So we are now in the future, and I think that at least gives you a little bit of a background. So let us go. I know we have about 10 more minutes, and I'm going to kind of quickly go through the first part of this, and we'll continue. But I want to have I'm going to show you kind of some excerpts from a oral argument. So we talked about jurisdiction, which is the first concept here. What is jurisdiction, Mr. Hassan? What is jurisdiction? What is jurisdiction? The definition of jurisdiction.
The power to speak the law, its literal meaning.
Power to speak the law. It's a Latin word, right?
Yes, sir.
And so when we talk about jurisdiction, what are we talking about, Mr. Hassan?
Diction of the law, basically interpreting the law.
Exactly. And what, in terms of how courts are operated, what does the word jurisdiction mean in that context?
Before any court can hear a case, it must have jurisdiction over the person or company against whom the suit is being brought against, meaning the defendant, or over the property involved in the suit.
Okay. And what does it mean to have jurisdiction over the persons? You can have a seat, Mr. Calloway.
Generally, a particular court can exercise in
What's that? In personam. In personam. And again, another Latin word. Have you noticed how much Latin is being used here? Some would argue, well, why is Latin being used, right, in the context of courts, right? Because we don't speak Latin in the United States, at least, right? So that, and again, that to some extent goes back to the argument about inequity and how, again, the laws were there to essentially, again, we talked about the courts of common pleas were the origin of the law, of the courts that we have right now. And the courts of common pleas were for what type of people? The common people, right? And so it was the common people basically being essentially managed by who? The wealthy, exactly. And the wealthy spoke what? Latin. And so even to today, you have still the manifestation of this. I was in court just yesterday, as a case in point. I'm in court, and again, the other side was represented by, a large law firm, and even though this large law firm was not supposed to be representing the other side, the large law firm was supposed to be neutral, right? They represented the other side. And so the judge, you know, unfortunately, he had a bias towards who? The large law firm. That just so happened to be represented by, again, a person who was Caucasian, right? And so automatically I came into that case, again, facing what we're talking about in the context of this word, again, a bias towards the wealthy, in particular towards, again, Caucasians. And this is in a court that is being paid for by our tax dollars, right? That goes to what type of discrimination, again? Another Latin word? It starts with a D? De jure. Again, when your tax dollars pay for unjust treatment. That's what's called de jure. De jure discrimination. All right? Continue.
In personal jurisdiction, personal debt, over any person or business that resides in certain geographical area, a state trial court, for example, normally has jurisdictional authority over residents, including a particular area of the state, such as a county or a district.
So again, going back to this point right here, I'll bring up this this image here. So again, you have these state courts, as was stated earlier, right? But the state courts can't exercise any, again, authority. They can't try a case unless that case is within their domain, right? Within their jurisdiction. Thank you. So again, that's one of the ideas, is that the person or the company or the subject matter being land has to be within their territory. And that's the context of state jurisdiction. On the federal court level, federal jurisdiction can happen when it deals with, again, the actual type of case. So if there's a law, the laws itself, which, and this goes to, again, the next person, or the next element, because one is the jurisdiction of the over the parties. The next area, so again, going back to on the federal side, if a person, in order for us to exercise jurisdiction over a party in the context of a federal court, what must that party, where must that party be, Mr. Calloway?
The federal government is a government of limited powers. The jurisdiction of the federal court is limited. Federal courts have subject matter jurisdiction in two situations: when a federal court.
No, I'm asking subject matter jurisdiction.
Subject matter.
I'm asking on personal jurisdiction. When does the federal court exercise personal jurisdiction? Or how can it exercise personal jurisdiction?
A court can exercise jurisdiction over property that is located within its boundaries.
Exactly. So in the context of a federal court, where must that property be located? And what does that mean? The boundaries.
In the realm of jurisdiction.
And what does that mean, Mr. Copeland? What does that mean? For the federal government, the United States federal government, to exercise, again, jurisdiction over the person, where must that property be, or where must that person be located?
We'll only exercise jurisdiction over property that's located within its boundaries.
Okay, so what does that mean in the context of the federal government? Look, I'm challenging you guys. You might not, again, you have to, again, analyze this and not necessarily read it. That's why, again, reading before coming to class, we can now, these kind of questions can be asked. Yes, ma'am. Ms. Green.
You said in federal court that it have to be resided in the United States?
Within the United States, right? In order for the federal government to exercise jurisdiction. Mm-hmm. So then how can the federal government go and authorize the abduction of somebody over in, let's say, Somalia.
They have to get the permission of the Somalian government in order to do that.
Again, idea of jurisdiction being exercised not even in the boundaries of the United States is, to me, personally, a question that I think is open for debate. But the United States government, however, has again seen fit through the orders of the Supreme Court to suggest that, again, under the idea of the global war on terrorism, for example, if somebody commits a crime outside of the boundaries of the United States, they can still be, again, subject to the laws. The subject of the law against subject matter jurisdiction can still be put on them, even though there's no personal jurisdiction. That, to me, again, makes absolutely no sense in terms of fairness, right? But that is the way the laws are structured. Okay. You can have a seat, Ms. Green, and also Mr. Cowley, but Mr. Copeland. Now, tell me about subject matter jurisdiction, since you were going in that area. Subject matter jurisdiction. Last question. All right, we'll pick it up right there.